more a benign dictatorship when we have
Hello?
some good doing?
Okay, good.
It's better.
Hello, everyone. Good morning. My name is Grant Yang. I'm the president of Duke Law's Intellectual Property Society. Welcome to our third annual Hot Topics in Intellectual Property Law Symposium. This morning, I'd like to introduce kind of our program. In the morning panel, we have 5 speakers talking about the MP3 privacy and piracy issue. Followed by the morning snack, we will have a politically incorrect style debate. And then we will have a keynote speech by Judge Randall Rader, followed by some breakout sessions. So you have several options to go to biotech and nanotechnology and those types of panels. Before I get this panel started, I'd like to recognize 3 groups of people. First, I'd like to recognize our speakers for coming here. Obviously, we wouldn't have a symposium if they didn't do that and take the time out of their busy schedules to come here. Second, I'd like to thank our sponsors, in particular Miles Beagle, who we've had a long-standing relationship with, and they're our highest level of sponsorship at the Director's Circle, and also the Center of the Study of the Public Domain, and in particular Director Jennifer Jenkins, and thank her for her continued guidance and support. Finally, I'd like to recognize anyone that you see with an IP board member on their tag. The IP Society is a completely student-run event, and just working with all the students and having worked with the faculty, I have seen the IP program, just even in the few years I've been here, grow significantly. And even at last week's Admitted Student Weekend, I met new recruits, and I think it's a testament to Duke's continued improvement of the IP program here. And there's no one that can speak more to that than Dean Bartlett.
Thank you, Grant. I just want to make a couple of very quick points. First, this conference represents the intersection of 2 of Duke Law School's really magnificent strengths. One is the strength in intellectual property. We have been undergoing, many of you know, since the year 2000, when I made the mistake of putting David Lange on the appointments committee, a virtual frenzy of hiring in the intellectual property area. And we now have national recognition and superstars in really across the area: entertainment law, internet law, biotech, telecommunications. It's really, I'm missing something, but it's really a fabulous group and getting stronger, so we're really proud of that. We're at least as proud as the other strength that I want to mention, which is student initiative. This entire conference was the result of student effort, student energy. We try to make a habit here at Duke of putting our support behind those activities that students indicate through their own efforts and goodwill that they have an interest in and are willing to see through to the end. And obviously the quality of this program, your presence here, and the intellectual exchange that is anticipated today is a good, strong indication of that. I also want to thank the sponsors, and I think this is a really nice tradition that you've started of having the sponsors so visibly indicated on this banner behind, so I think that's really neat. And I especially want to thank Grant for just a fabulous leadership of this group. One of the things that helps us to maintain visibility in the intellectual property area is having a good core group of students who are interested, informed, energetic, and who keep things like this Hot Topics conference going. I guess there couldn't be a hotter topic than the hot topic chosen this year, and to introduce the panel and to say more about the significance of the topic of today's Hot Topics seminar, I want to introduce David Lange, who has really been the centerpiece of our intellectual property efforts and faculty. David.
Thank you, Kate, and thank you, students who have organized this enterprise. This has been an impressive effort across the academic year as the students began to think how to put this together and then whom to invite and what topics to cover, and truly is an impressive effort. And I want to acknowledge the really, I think, brilliance of the program which they have put together for this morning. You will notice that I'm not on the program, and I want to make it clear that I did not insist on being on the program. I was actually asked late if I would introduce this panel, and I'm happy to do so. It's a subject that is interesting to me in a multiple set of dimensions. I intend to speak only very briefly, and my challenge or my obligation to the students who ask me to speak is to put this in some context, but rather more particularly to say why it is that a subject of this kind is important, why it is that we should spend our morning on this subject, and I'm happy to do that. I would say that there are two reasons, one broad and important, and the other even broader and more important. And the broad and important first reason is that, in a very real sense, the question of peer-to-peer file sharing threatens the survival of the recording industry, and with it, the music industry as we have known it, particularly in the last 30 years. But not merely in the last 30 years, for the recording industry didn't spring from the half shell in 1971. It actually has been an industry that has served Americans and for that matter, people around the world over a very long period of time. It goes back, as you can imagine, to the late 19th century and arguably even before, though not much before, because there was a point at which there was no recording technology. To see an industry of this kind fade and perish is not a small matter. And so, to the extent that peer-to-peer file sharing does threaten the survival of the industry, and I think it does, I don't mean to say that the industry will fail, but there is very good reason to think that it may, if something is not done, is to articulate one of the reasons why the subject that we are here to attend upon this morning is important. There is a second, and as I think, even broader and more significant reason why this is a hot topic. This is perhaps the first, it's not the only, there is a close companion issue or set of issues in the motion picture industry, but that industry's relationship to file sharing is somewhat more attenuated than the recording industry's, and I think doesn't quite fit the paradigm that I'm about to articulate in exactly the same way that the recording industry's paradigm is important. This is nothing less than a referendum on copyright that we are looking at. And that's an important subject indeed, because copyright has been with us from the very beginning of the Republic, since 1791. Copyright is provided for constitutionally by the Intellectual Property Clause, Article 1, Section 8, Clause 8. There is no question that the framers understood that we would have a system of copyright, and no question that the copyright system that we began in 1791 was one that they approved, and one that they supposed would, in the long term, promote the progress of science and the useful arts. But never before our time, have individuals massively confronted copyright in their everyday lives in the way that we now do. And to the extent that individuals are free to vote with their feet, and they are, vote in the streets, and they are, or vote on the keyboards of their computers, and they are, just to that extent, what we are looking at is this question, as I say, of whether copyright is to survive in the incarnation of it that we have accustomed ourselves to until this time. Now, as to that question, any number of people can play and speak and opine, and I don't pretend to know more or to think more clearly about those issues than anyone else. But if you ask me why this subject is important, it is because it is the surrogate for a much wider set of questions about whether or not copyright can survive. So if we think about the survival of the recording industry as an important question, and it is, and then think about the survival of copyright as an important system of law, and I put it to you that it is, then you will have some sense of what it is that we are attending upon as we turn to this really quite remarkable panel of speakers who have agreed to come this morning. The chair of the panel is Raymond, who is a professor at Case Western Reserve and who is seated second to my left in the panel, and who will, however, I think out of a sense of deference and decency as chair, speak last. Am I not right about that, Raymond? But never forget that he is, in fact, the chair of the panel. And I suppose, as I look at the lineup and the program, the order otherwise will be as it's listed on the program. Jim Berger, who is a practicing attorney in the Washington office of Dow, Loans, and Albertson, which has been historically, for a very, very long time, going back to way before my own time in law school, which was a very, very long time ago, a leading law firm in Washington dealing in the beginning with telecommunications or FCC work, but now having a much broader set of briefs. Jim will talk about this question that I briefly introduced and will tell you whatever it is that he thinks about it, and he's seated here immediately to my left. Next will be Jason Shoultz, who is staff attorney at the EFF, or the Electronic Frontier Foundation. The EFF is an interesting organization indeed. The EFF is one of the early proactive, pro-public domain organizations which have sprung up across the country in many dimensions and incarnations in response to what has seemed to many observers to be continuing threats to the public domain. The Electronic Frontier Foundation is a foundation that has particular concerns for the relationship between individuals, the internet, and copyright proprietors, among many other things. And he will speak next, and is fourth, I guess, from my left. Dean Garfield, who is at the very end of the panel, comes from a much maligned organization, and in my view unfairly maligned organization, the Recording Industry Association of America, where I can tell you that the people are in fact quite decent, do not wear horns. I believe you'll see that his hair is cut short enough that you could see if he were wearing any, and he doesn't. Beg pardon? It's removable. I think he's taken them off. Here, you understand, horns are not actually frowned on. We like them here at Duke. I hope that you'll pay very serious attention to what he has to say because, and I don't mean to say that you shouldn't, everyone else. I rather take it for granted that you will with everyone else, but I want you to give him a full and fair and forthcoming hearing because the truth is, what he has to say about this controversy is of the greatest importance. It is this week, I think, is it not, or just last week, that the second wave of suits against peer-to-peer file sharers has been filed. I think in all the numbering something more than 500 additional suits. 532, is that right? Yeah, right. And this represents, I can tell you this, this represents a signal change in the policy of the RIAA. I've known, I won't say who it is because it seems impolitic since he's not here to defend himself, but I've known a very senior officer of the RIAA well for nearly 20 years, and at the Copyright Society's annual convention just a couple of 3 years ago, I asked him whether or not the RIAA would ever actually consider suing individuals, and particularly college students, and he said, oh, well, no, of course not, we wouldn't do that, because what we really are interested in is in commercial pirates. If you want to gauge the sense that the RIAA and the industry have of the decline in their fortunes, consider the fact that now nearly 1,000 suits have been filed within the past 8 months. It's a serious problem. And finally, Mark Ishikawa, who is the Chief Executive Officer of a company that actually specializes in internet technologies. And since those of you who have been my students know how little I actually know about internet technologies, though I am delighted to introduce you, I shall say very nearly nothing at all, because almost anything that I would say would reflect my great age and my great ignorance. This is a wonderful panel, a wonderful morning, a perfect start to what I think will be a wonderful day, and I'm delighted to introduce the panel and turn the discussion over to Raymond Koo. Thank you.
Good morning, and thank you for coming out. Hopefully the coffee's taking hold on you. 3 disclaimers. The coffee isn't working on me yet. Number 2, what I'm about to talk about is my views, not the view of my clients who are primarily in the information technology industry, my partners or my law firm. And the third one is, thank you for that wonderful introduction, Professor, to the topic. And I have about 15 minutes to try and say something meaningful. After that, it's going to be very difficult. You know, copyright, is it under siege or overplayed? And I think I'm not going to try and answer any of these questions. You may sense my biases and prejudice on this, but I want to try and put it in context. From my point of view, copyright is good. It's been fundamental. The professor gave a great introduction to it. I care about it. My clients care about it. We suffer more in hard goods piracy, actual piracy. Forget peer-to-peer, because lots of programs are traded over peer-to-peer as well, but some $13 billion just in hard goods piracy. Although I do think Microsoft sold one copy of Windows XP in China, which was used to make all the others. So I'm not questioning its value. The dilemma that we're facing, and well set up again, was what do we do about it? And I think we need to be very careful in deciding what we do about it, because there are a bunch of complications in music copyright, which are sort of historical, maybe barnacles, and others would say perhaps fins on copyright that have been attached over the years to deal with a lot of problems that are similar to what we're facing today. There's a divided copyright in every CD, and sometimes it gets divided three ways. Mechanical rights, which is a compulsory license that the music industry insisted on just after the turn of the century, and back in the last revisions of the Copyright Act said that this compulsory license was wonderful and resulted in the great music and culture we have today. There's a performance of it in the CD, and that's often divided because the larger, the more talented people, and I will name, I think you're a friend of mine at some point here, but the industry has complained, the RIA has complained about this problem of these divided rights. Stars like Michael Jackson and Madonna just licensed the record labels the right to reproduce their song, and they hold it, so they decide whether they want it on the internet. You cannot find any Beatles music on the, oh wait, you can find Norwegian Woods on the panpipes. Other than that, you can't find Beatles online. Michael Jackson owns the mechanical rights, won't allow it. And as I said, the labels and artists aren't always allowed, and there's some unequal bargaining power which upsets these rights sometimes. But the one thing I want to say is that all of you, raise your hands, who knows who Doug Adams is? Oh good, at least one person.
No, operator, give me the number for 911.
Let's not panic. Numbers are thrown around all over the place. Look at all numbers skeptical, even my 13 billion, although that's actually the value that surveys have shown that the pirated goods have been sold for, not their actual list price. So, and we may get into numbers later, but I'd rather not take the time now. So, it takes a village, and I think that's where the professor was going. Whose responsibility is it for protecting music? And when I say protecting, I don't just mean enforcement. I mean the whole system that creates the great music that we have today. Should it be, where the burdens fall? Music labels, consumers, device makers, artists. I mean, we need to think about this as a kind of system that's all working with different wheels spinning that are often crashing into each other. The concerns of my industry are, and this is one of the things I have to give praise to the RIA, they recognize this. Our friends in the movie industry have a different view, that governments coming out and regulating, telling you how to build those devices, we think is a bad mistake. It tends to chill innovation, and I'll give an example later. So what's the reality? And that's at least my good friend, who I've known for over 20 years, Kerry Sherman. Is his title now president or executive director? He's a wonderful guy.
Yeah, it's president and chief legal officer.
Yeah, CLO. I always wanted that title. In any event, guys, I got to keep moving here. Kerry said there are three things that the music industry needs to do. This is about 8 months ago, debating Fred von Lohman of the EFF. He said there are three things that the music industry needs to do to combat peer-to-peer. One, get in the market. Two, get in the market. You can all guess what three is. Get in the market. I would add two things to that. I would add you need to educate and enforce judiciously. So I want to read something to you, which is a new technology has set the music industry on its ear. Threats of suits and countersuits are exchanged like litigious call and response. Congress holds hearings, and much official fretting ensues. From lawyers to musicians to listeners, I should add to professors, everyone is asking, can copyright cope with this innovation? Any of you have an idea what that innovation is that was being talked about? So what happened? This company Aeolian came out with a player piano, because the way music, the music industry wasn't really a recording industry yet. They were on the edges of it. Edison had invented this wax cylinder, so we wouldn't ever have to write letters again. He didn't think music was very important. And Aeolian produced these piano rolls, because the way the music industry, which was very successful, called Tin Pan Alley, survived on copyright was sheet music. And of course, this was mechanically punched holes in this roll of paper. And ultimately, the Supreme Court said, well, the 1870 Copyright Act didn't cover that. But by the time they got Congress to change it, Aeolian had scooped up most of the copyrights. So the industry created a mechanical license that once something was performed publicly, anybody could take it and record it and sell it. You just had to pay a federally determined fee per recording, mechanical reproduction. So what was the next great threat to the music industry?
Hey, Abbott. Yes, Costello? Are you the manager of this baseball team? Yes. Who's on first? That's right. I mean, the fellow's name. Who? The guy on first. Who? The fellow on first base. Who was on first? What are you asking me for?
It was the radio. Again, you read the lobbying and the testimony before Congress in the 20s, the radio was the devil incarnate. You could just substitute peer-to-peer for it. Of course, what wound up happening is there was a compulsory, it was actually a consent decree that resulted in a compulsory license for the radio stations. And it turns out that the recording industry decided the radio was quite good and started paying the radio stations to play music. By the way, Tin Pan Alley, they paid the vaudeville performers to sing their songs so they would sell. And we've had lots of other examples. Audio cassette tapes were going to be the death of the industry. Digital audio tapes, that was an interesting one. We'll talk about that a little bit, which resulted in legislation that I always said was ill-conceived. And of course, we have the issue we're talking about today, MP3s. And there's one that nobody's talked about yet, and I don't have time to talk about, digital radio, transmitting CD quality unprotected music. We'll hear about that at some point, I suspect. So let's talk briefly about the Audio Home Recording Act. This was the music industry's reaction to the first digital copying device, digital audio tape, which was going to take the country by storm, replace the analog cassette deck. I'm sure every one of you has a DAT in your home. You don't? All right. So what happened was the consumer electronics industry and the music industry got together and created a technological mandate, which was literally a 2-bit copy protection system. Had 2 bits in the CD that you had to go look for to say what it would be, how you would protect it. The computer industry opted out of that. And this is the problem of government intervention. It took several years for the legislation to pass. They didn't import the devices. They put a levy on the devices, which is like a tax to pay artists, which I'm not a big believer in levies. And the format died. Now, there's probably a lot of reasons it died. I don't want to blame the legislation necessarily, but there was one more thing that wasn't helpful. So what, of course, happened in the aftermath? MP3s and CD burners. So what was the historic response to that? The music industry began the Secure Digital Music Initiative, which I spent a lot of time in, and this was the response in 1998. The record labels organized SDMI, and the equipment manufacturers and software companies joined in. And what it was calling for was the development of a single digital rights management system to protect downloads and transfers of copyright files. What my industry and the consumer electronics industry hoped that in 98, because we were talking in 98 about the potential problem that was looming of MP3 distribution, that we wanted them to get out there and distribute music online for pay and protect it with a DRM. There were lots of problems. And the problems were manifold. The problem of our industry agreeing on one standard. It's very difficult for the computer industry agrees to lots of standards, but they're not mandatory. You know, you're free to use a standard or not, and it succeeds or fails on its own merit. So what we got instead was this thing, an SDMI compliant device. Remember the famous Biddle diagram named after one of my clients? It's somewhat incomprehensible. I wish I had a laser pointer. The problem with it is up there in this SDMI protected content phase 1 screen trigger. What that was to do was to prevent you from putting ripped CDs onto this device. And it was not a very successful effort. As I said, there were different issues. It was sort of a King Canute sitting, waiting, commanding the tide not to come in. Everyone, and you know, I'm not trying to put blame on the record industry or my clients, but it just didn't work. It wasn't a market-oriented solution. We all agreed that DRMs were useful, but we couldn't figure a way to protect CDs. That was out. The same guy who wrote that diagram, when everyone was talking seriously, would start whinnying like a horse, meaning not only is the barn door left open, but the barn's burned down. You can't put things back in. The few companies who put SDMI devices on the market, those devices failed. The Wall Street Journal critic of technology, Walt Mossberg, said, that makes me feel like a criminal. And this is an honest guy. So SDMI, moribund, didn't work. And of course, unprotected MP3 players became popular. So what happened next? Napster, right? And I'll breeze through this because I'm going to run out of time, but I'm still under time. So, you know, Napster is Sean Fanning's killer app. And it was a killer app in a lot of ways. It allowed users to trade digital music, as you all know, that are in their file, no one really knows the total number. There were 100 million unique IDs on Napster. It doesn't mean there were 100 million people, but some people have said someplace between 60 to 100 million people violating copyright. No question about that. But there's something beyond just the violation of copyright. It is voting with your feet to a certain degree. So, of course, as those of you who have taken copyright know, Napster was found guilty of contributory and vicarious infringement. The Ninth Circuit said they exercised control over the users. They had these central servers that could control it. And at the time when they got, the recording industry got that judgment from the Ninth Circuit, that decision, I said this was sort of like the Sorcerer's Apprentice, Mickey Mouse with, what are they going to do? Are they going to try and chop the broom, or are they going to try and make it work for it? And of course they chopped the broom, and what happened, this was what Bertelsmann had said, let's buy Napster, try and make it work. The rest of the industry disagreed, and I'm sure for good reasons. So what's the aftermath? Well, of course, Napster's gone but not forgotten. What we have in its place are Napster clones, which has the same music sharing capabilities, but their lawyers and engineers read the Ninth Circuit decision, and unlike Napster, there's no centralized controlling index, no control over the users, or so they say.
Be seated. We're now set to argue the case of MGM versus Grokster et al.
So those of you who know Judge Wilson's voice will know he ruled, it wasn't quite no harm, no foul, it was no foul, but he said there's probably harm here, but the law is the law, and Grokster or Kazaa, they're not guilty because of contributory vicarious because they don't control the user. I'm sure the RA will appeal that. In fact, they have appealed that decision. Then we have the issue of individual lawsuits, which I won't spend a lot of time. The district court found that Verizon had to respond to these clerk-issued subpoenas. Verizon appealed to the D.C. Circuit, and the D.C. Circuit said, read the words in the statute. These subpoenas don't fall under Section 512. Again, I'm sure there's a lot of disagreement we could talk about later. Legitimate online distribution has started. A little bit late in my view, but some good stuff is out there now finally. MP3.com, iTunes, the new Napster, which is pay per download. So at least there is a market beginning to take hold, and Apple's been very successful at that. And the tech companies in the RIA have a really good agreement that I support. It balances respect for copyrights and innovation, in my view, and we could talk more about that later. But essential details are education, as we talked about earlier, develop better technology-based protections so that we can get more people in the market, refrain from harming user system or violating their privacy. It's a little more than that, but I don't have time to go into it. I think it's a great agreement. So this is, So this is an issue that I'm not going to take a direct position on because other people are going to talk about it, but maybe I can tee it up just a little bit. And compulsory licenses, as I said before, nothing new. I'm not a fan of them, as I'll tell you up front, but it's been a historical sort of compromise between copyright holders, manufacturers, service providers, and consumers. There's a number of compulsory licenses out there. Examples are the musical, mechanical, broadcast radio, which is really from a consent decree, cable TV, webcasting. So it's not something unusual, strange, and foreign. And as I said, the mechanicals have been supported in the past in Congress very strongly by the recording industry. Is compulsory license the answer? And I asked that question and just give you a few thoughts. Right now, I think that if we go back to the 60 billion, and there's a big argument as to how many people have stopped doing peer-to-peer. I hope many have, but I think some have also been driven underground to Freenet and other places. But billions are being left on the table still. I don't think quite. I think what's started on online legitimate is good, but I think there's a lot of money left on the table. But I'm not a fan of the government setting prices and rules. I just don't think that's a good idea. There is perhaps the possibility that new musical groups can get compensated a lot faster, but again, remember, the government's involved. There's difficulty in collecting and allocating receipts, but I think in the computer age we could deal with that. I don't think levies work, and again, during question and answers we can talk about it.
We have you surrounded. Come on, put your hands up.
I don't think enforcement is the only answer. It's a tool, but to me it's the tool of last resort. So again, I asked this with a question mark, is there a to-do list? And you can tell this is probably my to-do list.
You can't fight piracy just with enforcement. You have to be offering legitimate alternatives.
That's Dean's boss, my friend, Carrie Sherman, and I agree with him 100%. Get in the market, That's the first thing. Try and figure out ways to take advantage of the peer-to-peer model. I think that's very hard. I don't stand here saying, oh, just go do it. Just tell your people to do it. I've been in these discussions since 1998. It's very hard, and we have old law in the way of doing that, and contracts and licenses. But I think we got to work harder on that. We need to give the public as many legal alternatives as possible to infringement. And we need to educate. I go around talking to high school students who are really bright about copyright and why it's important and what's legal and what isn't. And they give me some good feedback. And then judicious enforcement. Let's foster respect, not fear. So thank you very much. Save your questions and comments for later.
All right, good morning. My name is Jason Shoultz. I'm a staff attorney with the Electronic Frontier Foundation. We're a nonprofit in San Francisco that focuses on protecting civil liberties and freedoms in the digital world. And a lot of people often ask, well, what does that have to do with copyright law? And I think one of the things that the file sharing controversy has made a lot of people aware of is that there are a lot of things we want to do as consumers, as users of digital media, as users of technology. And the question is, can we do them legally? What should our freedoms be, and what should the rights of other people be? And I think file sharing has been a good example of the conflicts that can arise between what people want to do and what the rights of other people to prevent you from doing that might be. And it has presented us with a wonderful opportunity to explore what solutions to these problems might be. So basically, since 1999 or Napster, sort of hitting the scene, we've had this problem with file sharing, right? What do we do about it? No one's really sure. There are lawsuits going on. Napster got shut down, but these other services sort of sprung from Napster's grave. You have Grokster, Morpheus, Kazaa. They're still legal under the district court ruling that's on appeal right now. The recording industry has now decided to sue individual file sharing uploaders. I believe the suits are actually over 2,000 total, but Dean can tell us that. And at this point, really from that perspective, there's no end in sight, at least as far as we can see, that the lawsuits will continue, and it will become a world in which we have to decide, is this a world we want to live in? Do we want to live in a world where music fans and file sharers are continually investigated and sued, where their identities are subpoenaed, where they're tracked, where they're threatened with $150,000 per song that they're trading? Or is there a better way? Is there a different way we could approach this problem? I think we could sit here all day and talk about whether it's file sharing is stealing or not stealing, whether it's theft. I've been involved with a number of those conversations for years, and I find that at a certain point they just stop being productive. And so what I'd like to say, sort of, Jim has started us off here, is that I'm hoping today's conversation can really be about where do we go from here? If this is a problem, what is exactly the problem, and what solutions are there for us to consider, and what might we pick if we had to pick, right? If we had to choose something, what would that choice be? I was a Duke undergrad here, actually, in the early 90s, and I was a public policy major. And I remember one of the things I liked about public policy was it forced you to problem solve. They gave you all kinds of complex political, social situations, and they say you have to pick an answer. You can't just say this is a really tough problem. You had to actually compute the benefits and costs and come up with a recommendation, right? That was the whole point of public policy. And if you look at file sharing, from our perspective at the Electronic Frontier Foundation, we think the major problem is that artists and copyright holders are not getting paid. People love to file share. It's a wonderful technology. There's lots of innovation happening. There's lots of excitement about the possibilities of where music could go from here in terms of reaching broader audiences, new artists, new formats. All of this is very positive, but it is a problem that artists and copyright holders are not getting compensated. So it seems to us that the solution is to come up with a way to compensate artists and copyright holders. If you can do that without shutting down peer-to-peer, you've essentially solved most of the major problems that have come up from file sharing. There are still lots of other problems that are sitting around and affect the situation, but again, if you're going to have to pick a solution, you have to look at what are the major problems, what are the major deficits that are occurring here. So EFF has proposed a broad outline of a solution. It's not one that we came up with originally. We don't claim copyright in it. But we do promote it as an idea that we think could lead the way forward. And it's called voluntary collective licensing. And it's actually somewhat similar to broadcast radio. And Jim talked about that as essentially a compulsory license. But our take on where we would go from broadcast radio is more along a voluntary effort. And I'll talk about what the slight differences are between that. But basically, as Jim alluded to, broadcast radio is a model that's been working for years and years to pay artists when radio stations play music. And so from that, we've extracted sort of 4 premises for what a good solution, out of the tough choices, what the best solution might look like. The first is that artists and copyright holders deserve to be compensated for the music they create and promote. The second is that peer-to-peer is here to stay, and that is just a reality. And I think Mark Ishikawa is going to talk about the fact that his company is seeing file sharing numbers, continue to be very high. The numbers around 60 million users seem to be that it dips, but then it comes back up to around that number, maybe a little less, but it's still in the high numbers there, and that these software programs are going to continue to proliferate. Right now, the current versions of them are all still legal under the court's ruling and may be upheld by the Ninth Circuit. But what we saw from Napster is when Napster was shut down, more programs spattered up. This technology is fundamentally part of how the internet works. The internet is about trading information without approval, basically. It's about offering stuff up and people just exchanging it independently. And unless you fundamentally break the internet, you're going to have this capacity one way or the other. So peer-to-peer is here to stay. People are going to use it. The third is that music fans and file sharers are willing to do the work to distribute music. And this is a point that sometimes gets left out. The recording industry puts a tremendous amount of money into manufacturing, distributing, and getting the CD or the music download to you. They sort of have invested in an infrastructure. With peer-to-peer, it's actually the users who are doing that. They're storing it on their computers. It's their bandwidth that they're trading on and paying for every month. And we sort of take it for granted, but that's actually a willingness of them to, in essence, dedicate their computers and their resources to being a music distribution system, and something we could potentially take advantage of, going with the users and what they want to do instead of trying to stop them from doing what they want to do. The fourth premise is that government involvement should be minimized, if at all there. That the government should not be a part of the solution, if at all possible, and if they have to be, it should be as minimal as possible. And that's where Jim and I agree, that we think that there is a way that this can be solved without the government coming in and setting prices, without the government coming in and setting rules. I'll talk about this later, but if there is a role for government, it's very, very minimal, if at all. So with those 4 premises, how would it work? Okay, so basically radio stations, broadcast radio stations, work in a very simple way. Every year, they pay a blanket fee to collection societies called, their names are ASCAP and BMI, who represent songwriters. And they pay a blanket fee for the rights to play the music over the air. And once they pay their fee, they get to play whatever music they want. The songwriters don't get to tell them, yes, you can and cannot play my song, here this time or that time. They don't control what the radio stations do with the music on the air. And that's a very important point, because people, I think, when they think of copyright, think of property rights. And they think, oh, well, if I own it, I get to control it. Well, that's actually a situation that's worked out with radio where they don't actually control how it's all used. It's sort of a blanket agreement. You pay your fee, then you get to do what you want. And what happens is that BMI and ASCAP sample what radio stations play. Then at the end of the year, they collect all the fees from all the radio stations. They look at all the sampling that they've done about who's playing what. And they take the pot and they divvy it up. And the artists that were most popular on the radio stations get the biggest chunk. The artists that were least popular get the least amount. And it's actually worked out really, really well. ASCAP and BMI and the publishing rights associations have had unlike the recording industry, have had some of their best years ever. They've made millions and millions of dollars for artists. They continue to be one of artists' biggest sources of income. And it's actually, even in the era of file sharing, still ends up being quite a big payment for artists, and the system has not broken. So what would it look like if we did this for peer-to-peer? Okay. The first thing is, how do you collect the money? Our idea is that the music industry would form collecting societies, much like ASCAP or BMI. There could be 1, 2, 3, that, you can be competition between them for who can be the most efficient, come up with the best plan. And they would essentially go to file sharers and say, look, we know you're going to file share anyway, we know what you're doing, but we think that, with the threat of lawsuits and the kind of model you're looking at right now, we have a better alternative, which is pay us $5 a month. A $5 a month subscription for a license, essentially. And you can file share all you want. All you can eat file sharing for $5 a month. Now, there's 60 million people out there, roughly or so, file sharing, right? $5 a month times 60 million, that's $300 million a month. That's over $3 billion a year. And that's $3 billion of pure revenue with very little cost. Like I said, the users are doing most of the work, right? The recording industry is not distributing CDs at that point. And they're simply collecting the license fees. So it's a constant stream of income. As most of you know, like if you sign up for cable or your phone bill, when you pay a monthly fee or your internet service provider, you tend to keep paying the fee no matter how much you use it, right? So let's say, a lot of people blame the drop in CD sales on the current music, isn't very good right now. And people aren't buying it because the artists aren't, putting out good quality music. Most people under this system would probably pay the $5 a month, regardless of whether music was good or not, because of the chance that they want to use it at some point, or that they might want to grab a song if they hear it on the radio or something like that. I'll get to the question of why would they sign up, right? Right. Well, in that I'll get to that exactly. That's a good point. But I want to kind of lay out the system here, and then that's a good question. Nobody likes a heckler. Lawyers always like judges who heckle, right?
Right answer.
So, well, I will take your heckle in a second. So the other idea is that if peer-to-peer was legalized, the number of users using it would grow. So if 60 million is roughly the right number now, that would in theory grow, and that's only in the US, and maybe worldwide it would get even bigger. How do you divide up the money, right? So let's say you do get some percentage of 60 million people paying $5 a month. And keep in mind that for places like Duke here, it most likely would be that the university would simply pay a blanket fee for students and incorporate that into your student fees and say, okay, or you could opt in, you could check off, yes, I want $5 a month, added to my bill, for tuition so I can file share, things like that. There are ways to work it out where it would almost become institutionalized if you wanted to as an option, right? Again, voluntary, not forced on people, but certainly as an option. All that money gets collected, and then you can sample the file sharing networks to see which songs are being traded. You can get people who are listening to music to a sort of volunteer core of people to allow you to monitor what they're listening to anonymously. So the idea would be that if I have a little iPod and I'm listening to songs, I would have a unique identifier number that is not related to my name and who I am, but just it identifies the iPod or my MP3 player on my computer or whatever, and that it would send information back about what I'm listening to. These are the songs that I'm listening to. These are the songs that I like the best. It would go into a database, again, stripped of any personal information from me, aggregated, and that information could be used to figure out which artists are most popular. Now, this may sound very complex and technically complicated, and there are issues with accuracy and cheating and things like that. But on the other hand, this system is already being used today, both for radio and for broadcast TV. Broadcast TV, they're the Nielsen families, right? There are, I don't know, something like 2,700 of them. Those 2,700 families decide where billions of dollars of TV advertising revenue go every year. The advertisers who pay for TV spots base the rates and where they place based on a lot of marketing data, including the Nielsen families. It's not 100% accurate, but it's good enough for TV. Same with the radio. When ASCAP and BMI sample radio stations, they average sampling only 2 days a year for every radio station. So the entire year, they only sample 2 days. If your artist isn't being played on those 2 days, your artist doesn't get into the sample. But yet, the songwriters have understood that this is the model which is good enough, right? It's not a perfect solution, but it's a solution that they've accepted that makes money off of the technology and the situation we're in. So what are the concerns? And this is where I'll address Judge Rader's question. Right. How do you get people to sign up? Well, actually, I think, and a lot of people may disagree, but I actually think that people would take a fair deal if it was offered. I think right now, part of what they don't like about the situation is how they're being treated by the RAA. They're being treated as criminals instead of customers. And I think a lot of parents are very concerned for their kids. I think a lot of universities are concerned for students. I think employers are concerned for employees. I think there would actually be quite a bit of social pressure to take a good deal, which is $5 a month for all you can eat file sharing. I also think, though, that the threat of lawsuits is out there. And right now, while we don't agree that the lawsuits are the best tactics, if there was a reasonable alternative, right, I can take my chances and maybe I'll get sued and, ooh, this could be bad and I could face all this damages, or I could pay $5 a month, right? You're at least giving people options. If they want it, there'll always be people who would take those risks. There'll always be people who want to sort of buck the system or be pirates or do whatever they want, right? But then there'll be people who are like, well, this is a more reasonable alternative. I can live with this, right? It's about perhaps a compromise situation. And I actually think that that will actually be effective. But there'll be risk takers. And I think the question is not, will this solve the problem? Will this stop people file sharing? But is this a solution that is better than the current one we have? And that's my response to, will people do it? I think a lot of people will see this as better than the current situation they face. And I think all the players in the problem will see this as better than the current situation we have. Just very quickly, I want to address two criticisms of the system. One is that it's government price fixing. And I tried to lay out, this is actually not the government setting any prices or controlling the system in any way. The collecting agencies like ASCAP and BMI will come up with the fees. That is a market. Those are private entities. Now, there is, the RAA has expressed some concerns about antitrust. Well, maybe this would present some problems because they represent over 90% of sound recording copyright owners. That is potentially a concern, although I have not seen the Justice Department or the FTC express any reservations. I don't think anyone's actually asked them. We don't know if it is a concern or not. And if it is, like in the ASCAP BMI situation, or in other situations, you can have some minimal governance. You can have some supervision and oversight where they just make sure the deals are not being anti-competitive. They don't set the prices, but they review the situations to make sure that the copyright holders are not skewing things too much in one direction or the other. That's very different than telling them what to do in terms of setting the prices. And the last thing I want to say is that what about iTunes, right? Isn't that the answer? Well, why don't people just use that? The reality is, even though iTunes has been somewhat successful in terms of selling millions of songs, it's nowhere near as many songs as the file sharing networks continue to trade every day. I mean, Apple has just said it's not going to reach its number of 100 million by the time of April, which it thought it would. And you think about 100 million songs, sounds like a lot, but billions and billions and billions of songs are being traded on file sharing even today. It's really, if you talk to anyone in the music industry, a drop in the bucket. The other thing is that all these systems, you have, buymusic.com, Napster, iTunes, all of this, they're not compatible with each other. And if they go out of business, you lose your music. And I think that there are a lot of problems with all these different incompatible competing formats that file sharing could solve.
Good morning. I've learned over the years you should play to your audience, so I will say, though I left my horns at home, I am a Blue Devil fan. Also pandering to my audience. Based on everything that I've seen since I've been here, this school and the people in this room are the best and the brightest minds. And so what I would like to encourage you to do is to work with us to try to find a solution, to try to find a way out of the conflicts and the conundrum that we face today. I think rather than simply poking holes in the solutions that are being offered currently, we should put our energies towards trying to solve this problem. And I think this panel is a good starting place. So let me begin by congratulating the Intellectual Property and Cyberlaw Society for putting this program together. I think it's quite tremendous that these students have collected together and put together as an impressive program. And I look forward to coming back to the 10th version of this. I do think there is a solution that allows us to protect the public domain while allowing the continuation of copyright. I don't, however, think that that solution is statutory licensing. One of the things that Jason said is that it's important to give people options. how do we, if it's a voluntary program, how do we deal with all of the copyright creators who decide to opt out of this program? How do we deal with those who decide that they don't want their copyrighted content, their creative works, shared on these file sharing systems? That's problematic. I think that fundamental problem, the inability to give copyright creators a choice, dooms this solution to failure. It brings us straight back to where we are today, which is there are a large group of people, including the companies that I represent at the RIAA, who have little interest in seeing their files traversed or shared on these networks without any control and any say in how those files are being used. Without the ability for people to opt in or opt out, what we're left with is essentially a government solution, which is a mechanical solution, a statutory solution. And the question that I have is, what is the social good that this socialist solution is geared towards solving? It's not clear to me that, given all the problems that we have, that energy should be dedicated towards subsidizing the sharing of copyrighted content while divorcing control from those who create those works. One of the other things that I think is problematic is, though if you visit the EFF's website and look at the actual program, it says that no change in the copyright laws would be required in order to come up with this solution. In fact, it would require some substantial change in the copyright laws. If copyright creators are divorced of the right of determining whether their works are traded on file sharing networks, you're essentially taking away the reproduction, distribution, or public performance rights that these content creators enjoy today. It would drastically rewrite copyright and doesn't strike the balance of protecting the public domain, which is an important thing to do, while giving content creators the level of control that they enjoy today. I think the solution, whatever solution that we come up with, requires moving away from extreme positions. I think it would be inappropriate for me to say that those who trade files on the internet, those who decide to use peer-to-peer services deserve no level of privacy and no level of protection. It would be just as improper for me to say that those who are involved in creating works and coming up with new works of authorship deserve no level of control over how those works are reproduced or distributed. I think some balance needs to be struck. In trying to find answers, I think one of the things that copyright lawyers do quite often is to look to the legal precedents, and I would encourage your students to do the same. And the precedent that we keep coming back to is Sony, the Sony Betamax decision. And I think Sony strikes, in my mind, the appropriate balance, but it does not provide all the answers. I think one of the most profound statements about that decision came not from the Supreme Court, but from Judge Ferguson at the district court level. In rendering that decision, it said that the technological issues that confronts the court are much broader than the legal issues at stake. And so the solution was to look at the facts of that particular case and render a decision based on those specific facts, which is what the court did. The court looked at the fact that what people were doing with the Betamax was recording movies in their own homes of content that was being freely distributed and freely available over public television. The court specifically said that it was not confronting the issue of copying content from pay television or pay-per-view, and was not dealing with the situation in which there was mass distribution of the works that were copied from television. That's actually what we're dealing with today with the peer-to-peer services. it's not simply someone sitting in their home and copying works that are publicly available in the public domain. Instead, what you have are billions of files being traded, of copyrighted files, with all control being divorced from the content creator. There are over 2.6 billion sound recordings that are traded on these file sharing services each month. The numbers are staggering. I think Sony is, in fact, the beginning of the conversation, not the end. And that's the problem, I think, in the balance that was struck in the Grokster decision. Rather than focusing on the defendants and the defendants' conduct, the court viewed the case as being an attempt to stop a technology. Our position publicly and in the court was that our efforts are not directed at stopping the distribution or development of peer-to-peer technology. Our efforts were aimed particularly at those defendants and their conduct in, with knowledge, encouraging, and otherwise materially contributing to copyright infringement, which I would argue that they still do. I'll skip ahead to the issue of privacy. As I stated earlier, I think there, or alluded to earlier, I think there is a presumption of privacy. There is a presumption of privacy even on the internet. Looking at the line of Watchtower cases from the Supreme Court, I don't think you lose that privacy by walking outside or using a public tool such as the internet. There is still a presumption of privacy even on the internet. I think there is a sliding scale, and you lose some of that presumption of privacy, if not all of it, when you engage in conduct that's illegal. So using a peer-to-peer service to engage in either distribution or reproduction of music, I think you lose that presumption of privacy. And there is nothing inappropriate about suing individuals who decide to share with the world copyrighted content. Where does that leave us? What is the solution that will work? I think part of the solution, or the solution, since I have to agree with my boss, is, is getting in the game. I think that's occurring. Can copyright survive? I think it can. I think we can come up with a way of doing that. I think we have to be responsive to consumers and listen to what they're asking for. Music is as relevant as it ever was. The problem that we face in the recording industry is that people are less and less willing to pay for that music. We have to find ways of encouraging people to, again, pay for music. I think part of that is through education and engaging in an education campaign. Our litigation, in fact, against individuals is a part of that education. Before initiating those litigations in June of last year, all of our surveys indicated that the overwhelming majority of people, it's hard to tell whether they're telling the truth or not, but you have to take these surveys at face value, that the overwhelming majority of people did not realize that what they were doing was illegal. They actually thought it was legal. I, along with Carrie, received an email yesterday from an individual who believes that she is going to be a part of the latest round of suits. It was a college student. And in her email, she indicated that she didn't realize that what she was doing was illegal and that she was a student leader and did not want the world to know that she was engaging in illegal activity. She also indicated that she turned off the sharing on her P2P system, and so thought that, in fact, she was not distributing content to the world. Most people don't realize that, one, the action is illegal, but two, they really don't understand how that technology works. Disabling sharing is an option, but if you download a new version of that software, your choice to disable sharing has been lost. You have a new version of the software, and the default is to share with the rest of the world. Educating consumers and educating the public about how to use that technology and how to use it appropriately, and also the illegal conduct that they're engaged in is an important part of the process. I think another and an important part of the solution is using technology. We've said over and over without a lot of people believing that it's true, that we are not, in fact, anti-technology. I think the solution that was offered earlier of a statutory licensing regime leaves out an important aspect, which is technology. You don't need a collection society to keep track of what's happening on these systems. For these systems to work, each individual file is given a marker, a tag. So there's a hash associated with the file. Simply looking at that hash and looking at what's being traded across those networks gives us an ability to track what's being traded. It also gives us an ability to determine what should be traded and what should not be. And I think that's the solution, which is giving individuals choice. Not only the individuals who are using those P2P services, but also the individuals who devote their energies and time into creating original works of authorship. There is no reason, no technological barrier to filtering on the peer-to-peer services. I think filtering is a solution. You will allow those who are interested in protecting the public domain to continue to trade in works that are publicly available. On Kazaa, you would have all of the works that were stated in the litigation that are public domain works that people are interested in trading all the time. What would not be included would be copyrighted content where the copyright holder selects not to have their works traded. I think that's a more reasonable solution, and I hope that eventually we'll move in that direction. I have a lot of hope that, in fact, that we will and are moving in that direction. The Napster system is back in a new form. Many of the executives who were involved in that Napster system are now working on filtering and coming up with solutions to the problem we face today. And I think if all of us collectively work towards that end, I think we can come up with something that meets consumer demands while allowing copyright holders to retain some of the control that they exercise and enjoy today. Thank you.
You can put it on my stuff. Feel free.
Hi, my name is Mark Ishikawa. I'm the Chief Executive Officer of Bay TSP. As typical, I'm the only non-lawyer on the panel, so try not to beat me up too hard. And I'm probably also the most least liked person on the internet because of what our company does. We are the internet, essentially the internet private investigators. We go off and find people who are trading copyrighted content that belongs to our clients, and then we send out the enforcement notifications under the Digital Millennium Copyright Act. One of the slides I always like to start off with when I come to a university is the infringements that we've detected at Duke University over the last 90 days. Now, typically when I go to one of these presentations, I'll have 1 or 2 or 3 slides. You guys have 30 slides full of infringements over the last 90 days. Most I've seen to date. I was floored when I saw it. You know, we have people trading everything from movies, Hunt for Red October, Tupac Resurrection. I mean, this list goes.
What's the right column? Is that the bits?
No, the right column is the size. The left the left column is the file name. I'm sorry, the title, and the center column is the track. You guys have an awesome file trading network here. You guys are trading television programs.
Make sure I get the slide.
It doesn't have IP addresses.
The data is available. You know, beyond.
I'm surprised how little is pornography.
Well, you know, this is only the works that our particular clients have asked us to look for. So we're not looking at all the file trading that's going across the network. But as you see, we're still in movies. Okay, here we go. Now we're into the music segment. I mean, it just goes on and on and on and on. You know, now we're also trading software ranging from Norton, Symantec products. So you get an idea of the amount of file trading that's occurring even in the Duke University network. One of the things that I am going to go back when I get back to the office is to find out what the compliance rate is. That's typically we send out the notifications and then we wait for somebody who the DMCA contact is at the university to take the appropriate actions. And if they don't take the appropriate actions, then our clients' legal departments get involved. So if the lawyers start coming, sorry. Let me get into our actual presentation here. So what I'm here to talk about is really the lack of anonymity on the internet when you're using a peer-to-peer network. People have this false belief that they can remain anonymous. When you're connected to the internet, you have a unique IP address. Some entity is responsible for that IP address. We'll contact Duke University and say, somebody on your network at this date and time, we use a geosynchronous satellite clock, so where everything is timed down to the nanosecond. We're saying at this particular time and date, on this particular IP address, this person was sharing a file. And then it's up to the university who's responsible for that IP address to contact the student and get the material removed or block access to the content under the DMCA. What we typically find is that there are anywhere from 50 to 60 million people any given month using a peer-to-peer network. We see some blips in the in the counts. When there's a holiday, spring break comes up, the counts go down. Summer vacation, the counts go down. So we see a lot of it being university and educational based. It's not just your computer techies anymore. It's not the guys with the propellers on their head working in the labs. It's now down to the point that your average student can get a copy of one of the peer-to-peer file trading software and start downloading music. One of my favorite stories is I was having dinner in Los Angeles a couple months ago, and I'm listening to this conversation about these two people talking about how hard it is to get their music, but they're still able to get it and they're not having to pay for it. Curiosity gets the best of me. I look around the corner, and it's these people that are grandparents' age who are now running a peer-to-peer network system. So it no longer is the Pepsi crowd. The mindset is it really isn't theft. People don't believe that it is stealing music. I've gone to universities, and that's one of the things I do. I make 1 or 2 trips a month to universities to talk to the student body. And I'll get into these big debates with students where they're saying, I'll never spend another dollar on music. When I was growing up, it never crossed my mind to take a disc, 45, vinyl and run out the door with it. People today feel that they just have to go home and download the content. File trading is not on the decline. If you've seen the Pew study where they said 50% of the people have stopped downloading using the peer-to-peer networks, think about this was done on the telephone. Think of getting this telephone call. Hi, I'm with the recording industry. We're doing a survey. Are you still trading files? No. Of course, what do you think the answer is going to be? So 50% of those people, 50% of the people that claim to have stopped trading files, it absolutely isn't true. That Pew study, we have some issues with. I'll give you some stats on some of the download statistics. Christina Aguilar's song went from 0 to 41,000 copies in 31 days. An Angelina Jolie film that came out this last summer, from 0 to 6,000 copies available on the internet in a weekend. We found the first copy being distributed out of the Korea Institute of Technology, which I didn't even know existed, 3 hours after theatrical release. We're finding, again, movies 3-4 hours after release. Typically, that's the worst case. Sometimes we find them as much as 6 months in advance. Somebody gets a hold of it through the pre-production process. We worked with Universal Studios on the Hulk release where somebody had leaked it internally. In some places, typically, we have operatives that work for us in Southeast Asia. Within 3 days, we're able to find physical goods of discs of movies that have been downloaded from the internet. There's technology that's available that we police that we can tell exactly what screen that movie came from. So we know there's certain theaters that are hotspots for pirates. When we get enough of a case built up, we hand it off to law enforcement. They go kick the guy's door down. It's typically a camera operator, college student, and they go raid the room, and they have dozens of movies there. We do a statistical sampling of all of the file requests on the peer-to-peer networks. We find that over 90% of the requests that are made are not for legitimate content, but for copyright infringement. We believe that there are valid uses for peer-to-peer networks if you have a musical group that doesn't want to go through the label or the traditional distribution model. Peer-to-peer is a way for them to get their name out there. Our issue is when it's copyrighted content that belongs to our clients. Software piracy is just as bad as music and movies. Everybody has always known that it's illegal to trade software, or software piracy has always been a big point. But software companies are now realizing that it's now available on peer-to-peer networks, and they're starting to police it just as hard. We do work for Symantec. Symantec has seen, the first week that we put the system into production, there were 600,000 unique copies of Symantec software being traded. We send out, or we typically find between, it's actually 3.5 and 5 million copyright infringements a day. That's not all copyright infringements, that's just copyright infringements of the material that belongs to our clients. So there's tons and tons more out there. We send out more than 1 million DMCA takedown notices a month. We have what's called the recidivism rate. We build it as a case. The first time we find the individual, we create a case, just like a rap sheet. The next time you surface, we have your history. We send that along with the takedown notice that's saying this is a repeat infringer, this is your third strike, this is your fourth strike, what are you going to do about it? 80 to 85% of the people that we find and go through the entire case closure process where some action is taken, either the user comes back and says, I'm sorry, I didn't know it was illegal, or the ISP has turned off the connection. 80 to 85% of those people do not come back. Excuse me. Our record for takedown is 23 minutes from notification to takedown. That happened in Austria at 3 in the morning their time. A lot of ISPs are not like the US. In the US, you go buy an internet connection, you buy some modems, you're an instant ISP. In Austria, it's a government-run entity. And they understand that they have to follow the Berne Convention bilateral treaty. So they were very responsive. The P2P developers are getting smarter at developing the protocols. The Napster days were very simple. It was, you had a central directory. Now you have eDonkey, BitTorrent. Those are the latest and greatest in large file movers. But the problem is that they have these holes built into their system. EarthStation 5 has a backdoor built into it. Kazaa launches spyware with your software. The real problem is that the software developers are creating these utilities or tools, whatever you want to call them, and they're really transferring the liability for their actions onto their clients. So the people who are using the file trading software, they're the ones who are really on the hook for the activities and the illegal activities that are occurring. Users really should have no reasonable expectation of privacy when they're using these peer-to-peer networks. You can't say, I'm sharing these files with the world except BTSP. That just doesn't fly. So what happens is we make a request on the file sharing network. Everybody holds up a sign. I say, I want to find Finding Nemo. Everybody that has a copy of it holds up a sign. We just follow the signs back to the individual's offering and catalog that and report that back to our clients. There's, the technology that we have lets us identify and take action on every type of the peer-to-peer networks. So people who think that, oh, I'm safe because I'm using protecting software like Pure Guardian. One of my favorite emails that I got the other day is, how did you find me? I'm using Pure Guardian. There is no way to hide from us, and that's the problem. When you're on the internet and you're making your computer available, or these shared directories available, there is no way for you to remain anonymous.
You're making people nervous. I can hear see the nervous.
Oh, I could see it too, and I'm sure that when I get back, the car will be egged and everything else. Digital rights.
Mine's a rental.
Actually, I'm riding with a student, so even better. Digital rights management solutions. Somewhere down the road, it may be the answer. Right now, digital rights management is not the answer. It really is no way to come up with a completely foolproof DRM system. My background is I started working for the government 20 years ago. I started working on encryption and network security. the inception of our company was to create a digital rights management solution. Every time I'd create something, I'd send it to my friends over at the Lawrence Livermore Labs and say, how can you get through this? 5 minutes later, they say, okay, here's how you crack it. And the problem with the DRM solution is once one person is able to crack it, next thing you know, the content's free on the internet. You've also seen some other types of digital rights management or some types of management solutions where they've encoded the CDs where they wouldn't copy on the computer. And anybody that's internet savvy knows you get your black felt tip marker and draw around ring 0 and suddenly you have an unprotected disk. The Charlie Pride CD that came out a couple of years ago, another great example. You know, we had it cracked in 2 or 3 minutes. So there really is no way to stop people who want to trade the content today. You know, we're seeing a larger use of digital watermarking. Every video or every movie print that's made that goes out to a screen has watermarking built into it. I can tell you exactly what screen and what serial number of that movie was generated. I believe that the recording industry is going to be starting to do the same thing, if not already. In fact, we're doing some work with some of your guys in the anti-piracy space. It's really the fear, uncertainty, and doubt that we bring to the game. You know, you never quite know when we're going to find you. There's 60 million people. I hate to come across as a draconian kind of individual, but that's what our clients pay us to do. They pay us to go scour the internet for people who are trading their copyrighted materials, and it's up to you to take the chance. Are you going to be the one that, is today your lucky day or not? You know, there's the Digital Millennium Copyright Act was written in 1998. Prior, you know, when that piece of legislation was written, none of this existed. Is that me?
No, that's me.
Okay. You know, none of this existed. Peer-to-peer networks didn't exist. If you were going to trade files, you went to an FTP site, you went to an HTTP site. So we now have this dilemma between 512A and 512C cases. Does it really reside on the ISP's network? Do they have the obligation under the DMCA to take action? You know, we're pushing it both ways. We're trying to get our clients to continue sending the notices and takedowns. A majority of the ISPs understand that they need to do something about the takedown notices once they get them, regardless of whether it's on their network or not. We have some ISPs, SBC Bell, I'm sure you have a whole list of those that just tell us, hey, it's not our problem, good luck, come sue us. So, and that's what our clients are in the process of doing. Legislation is always behind technology. You know, it's going to be a couple more years till somebody actually writes a good amendment for the DMCA that comes through and addresses all of these issues. If you think about the problem, the ISP is the only person that knows how to contact the individual that's doing the illegal file sharing. So for us, we have to contact the ISP and hope that the ISP forwards the information on to the user. Typically, once the user gets the information, they say, okay, I give up. We have the binder of shame at the office. It's, you know, everything written from, you know, little 8-year-old girl, I'm sorry, I didn't know it was illegal. You know, to other people saying, screw you, come get me, and those are the ones that typically the clients go after. You know, when you go to the petting zoo, do you pet the tiger or do you punch him? So what we're expecting is some new legislation to help streamline the process of IDing the infringer. We believe that we're going to see a more aggressive enforcement activity. We see the RIAA doing it. We believe the studios are going to be doing it. We know the software industry is ramping up to do the same. We're going to see some new legislation that's going to hold the ISPs accountable to make sure that the information gets over to the infringer so they can do something about it. And we also believe that our clients are going to start pushing foreign nations who are not necessarily taking the same protective actions with U.S. copyrights as their own. So we believe in 2004, people are going to begin to realize that there is a major risk with stealing or trading for copyrighted material. We believe that there's going to be the telephone, that's a different issue. Technology is not the silver bullet, but there will be a combination of legislation, some very highly publicized enforcement, and it's going to wake people up to realize that, you know, this is a serious business. You know, the Pepsi commercial this year at the Super Bowl was not a real winner. Everybody's saying, "Oh yeah, hey, we were caught. You know, come to iTunes." You know, people need to take it seriously. They need to understand that this is, you know, that you can be arrested. We were responsible for 18 felony arrests last year, just to give you an idea. And these are not the people who are just trading files. These are the sources of material. These are the guys who are inside the camera booth, making camcorder copies, telesync copies. The problem that everybody has, including the music industry and the movie industry, you can't beat free. The current model, it's free. Just go online and get it. So there needs to be some type of earth-shattering event that wakes everybody up that says, stop it. And we're hoping that that's going to occur this year. So, thanks.
Sorry, I don't have my Clint Eastwood make you feel lucky punk sound file.
All right, good morning. First, I'd like to thank the IP Association for inviting me here. It's a wonderful opportunity, and this is a very excellent panel to be participating with. I didn't think I would be playing the role that I will be playing, given that I'm an academic and given that the Electronic Frontier Foundation is represented here, but it looks like I will be hopefully the one that will assuage some or perhaps your fears following Mark Ishikawa's be very afraid talk. And to go back to Professor Lange's comment that in many respects what we're talking about today is ultimately a fundamental debate that is a referendum on copyright itself. In my presentation, I'd like to be careful here because in many respects all the panelists today have made a very common mistake or usage of language, and that is to treat copyright as a unitary entity, unitary legal principle that protects all sorts of people but treats them all the same. I want to keep in mind that in many respects, copyright treats creators, distributors, and the public, and we need to keep those three particular groups in mind. And I'd like to start out briefly with a quote that might sound familiar to many of you. The copyright holder was arguing in this particular case that music is intended for the ear as writing is for the eye, and that is the intention of the Copyright Act, to prevent the multiplication of every means of reproducing the music of the composer to the ear. Those of you who have studied copyright might be familiar with this case. The plaintiff were sheet music publishers. The defendant, the pirate of its day, was the recording industry. And as already been discussed today, the result was not exclusive rights, but a compromise in which sheet music publishers and songwriters were paid, but the publishing industry was denied the ability to control this brand new medium in the recording industry. So the traditional discussion or the traditional equation with respect to copyright is this idea that, well, we have one very important group of interests, and that is the author, right? The creator of the particular work, the person that writes the story, writes the song, performs the song, right? But we also have to keep in mind that for the most part, that person doesn't do a whole lot of good to us without someone called the publisher, who prints the book and prints and stamps the vinyl album or the CD, as the case may be. And most importantly, with respect to the American version of copyright, it's very much an instrumentalist view that the whole point is to benefit the public. And in fact, for all the parties involved, unless the public actually has access to and takes advantage of these works, there's no point in the entire system. The problem, of course, is you really didn't need copyright necessarily. In fact, creation flourished for hundreds of, if not thousands of years without the concept of copyright, but it was limited. The author could only really admit a few number of people, and only a certain small select group could enjoy the works of a particular author, right? And you also have the problem of, to the extent that you're funded by patrons, only the de Medicis get a say as to what's created. Now, printers come along and they provide us with a very valid and important benefit, which is they get to admit more people and spread the joy of creative works to a larger numbers of the public. And so ultimately, copyright has been deemed quite valuable, and I would certainly not dispute that. I am a big fan in many respects of copyright, for since the creation of the Statute of Anne. Now, the reason here is, well, the traditional kind of economic assumption that if you allow copying, unauthorized copying, ultimately that copying, even though it may increase the number of works in the short term available to the public, it will ultimately lead to underproduction. It will ultimately mean fewer authors will write, and worse, fewer publishers will distribute those works to the public. As a result, copyright was necessary to step in and correct this, right? Copyright is the answer that balances this particular equation. Now, the problem is we're starting to see with peer-to-peer technology in particular, but the internet and digital technology in general, is this is a technology that may very well change the fundamental equation that we've been used to. And so we've been used to the author, the publisher, and the public. Well, what do we see when we see peer-to-peer technology? What do we see as Mark Ishikawa describes the number of files that replicate, as one court has suggested, virally at the speed of light around the world? Well, what we see is the publisher and the distributor starts to drop out of the picture. And in many respects, it is replaced by the public. Now, this is fundamentally revolutionary to copyright in some respects, but it's also been the case that changing who the distributor is not that new to copyright. As I started out the presentation with, sheet music publishers were the original copyright holders. Recording industries came along, well, they were new distributors. Broadcast came along, and Jim unfortunately has stole some of my thunder with there, and they ultimately were able to obtain very beneficial use privileges in many respects without the control of copyright owners from the recording industry or the songwriters themselves. All right, now, in each of these instances, the question is, well, what happens, right? What should we do? And the question is, are we facing today, in many respects, a new paradigm? We've heard copyright described as a paradigm already today. Well, we have a paradigm that potentially means that if an author creates one work, now the entire world, the entire public connected to the internet, and we can assume that as long as we bridge the digital divide, eventually everyone will have access to the internet, will have access to that work. Now, what does that mean? Is copyright still the solution in this particular paradigm? Well, the problem here is exclusive rights, especially when you talk about distribution, lead to under-distribution, right? Because copyright gives the owner, the copyright holder, the exclusive authority to determine whether or not to sell the work and what price to set in response to the market. There will inevitably be people who will either not pay or be unable to pay, right? So in this particular paradigm, instead of producing greater access to works, in some respects, copyright may very well, again, reduce access to works. Now, the bigger problem has to be creation, right? And even if I'm right, even if what we start to see really is a change in distribution, that's irrelevant if there's nothing to distribute. So the real question is, well, what do we do about creation? And it's not all that clear that exclusive rights are the best solution for creation. And we'll talk about why in a second. Here, well, when we strip the distributors away from the equation, we find out, well, lo and behold, especially for many industries, and this is in many respects has to be an industry by industry question, that frankly, there is in fact a lot of money available to fund artists and fund and create incentives for creation. So ticket sales alone is a tremendous source of income. Those of you who are familiar with the recording business are probably aware that most performing artists, that is how they make their living. Most do not make their living by sitting on the beach collecting royalty checks. They make their living by touring around the country and working for a living. Now, what does that mean? In 2003, that was a $2.5 billion market in recording, in music performances alone. That's a substantial amount of money. Bruce Springsteen, the boss, made $116 million in ticket sales alone in 2003. And the same's true for the motion picture business. $9.5 billion in 2002. They haven't released their 2003 statistics yet. Now, when one also considers that in addition to this, there's also the question of commercial licensing. I mean, one thing that we have to keep clear when we're talking about peer-to-peer file sharing is this is consumer copying. It's not for-profit copying. I would agree that with Mark that his clients that they've thrown away for selling commercial copies, that's one of the reasons why copyright was enacted. The problem has been trying to import that model to circumstances in which consumers are not deriving any profit by doing this. Now, we can kind of play with the idea of what's commercial value because I don't have to pay for something that I might have paid otherwise, but it's still not for profit use. And then when one considers the fact that levies and compulsory licensing have worked in many other contexts, the argument that you need exclusive rights and that copyright has to be extended to peer-to-peer use becomes a lot more troubling. And I raise this as a question, one, as a matter of public policy, but also is a question of what should courts do? And in particular, as the law professor, I'll get to talk to you about that today. And what should courts do? What we're starting to see in many respects is they have two choices. One choice is presented by cases like White versus Smith, in which the Supreme Court found in favor of the recording industry and against the copyright holders of sheet music, and that is interpret copyright narrowly. Right? It may be possible to expand copyright to include file sharing, but there are problems with doing that. And what I've hoped to kind of briefly sketch is that there are a lot of difficult empirical questions involved. Right? In addition to the empirical questions, we have to ask the policy questions. It may very well make sense if we're concerned about creation to say that, well, we want to deny a large number of people access to works if we think that the benefit of creating a couple of additional movies a year, a couple more books a year, is worth the cost of that particular trade-off. And the real question is, should courts be making this particular decision, or should Congress? Right? I mean, to the extent that the proposal law are private solutions, that's fine. In fact, many respects, one would hope that though I don't have the same faith as others do, that the private markets will necessarily resolve themselves, it will inevitably be a court controversy as well, as the 2,000+ lawsuits are already illustrating. Well, I'd like to suggest today, as the professor, that we should look back to the past to find a particular answer or the approach to this question, and that was presented by the Supreme Court in the Charles River Bridge versus Warren Bridge decision back in the 1800s. Now, many of you are probably unfamiliar with this case. It used to be a staple of the Academy, and it has since fallen out. And in that case, we had one set of exclusive rights holders, the builder of the Charles River Bridge and their investors. This was considered at the time one of the most important public works projects in the country. It was one of, in the 18th century, the sights to come and see in the United States, because building a bridge to cross an expanse as wide as the Charles River was unprecedented. And the only reason, according to the investors, that they did it was because they received exclusive privileges from the state of Massachusetts that to guarantee their investment, to put up the funds and join this endeavor. Time goes by, the bridge is a tremendous success. It leads to commercial development and commerce and greater communications between Boston and Charlestown, and arguably across New England, because it was a fundamentally important replacement and advancement in technology over ferries. As you can obviously understand the limitations of a ferry versus a bridge. Well, time progresses, and the original grant was somewhere along the lines of 60 years, which was subsequently extended. Sound familiar? And Charleston decided, well, this isn't enough. The bridge is not providing us with the services we need. We need more. We're a growing community. And what they decide to do is charter another bridge. Now, the problem for the Charles River Bridge investors is they decide to put it right next to the Charles River Bridge. And after a brief period of time in which the bridge would be authorized to charge the same tolls as the Charles River Bridge, it would be free. And much like the debate today, the Charles River Bridge owners said, hey, you cannot compete with free. And in that case, it was true. Right? By the time this case reached the Supreme Court, the value of an investment in the Charles River Bridge was zero. Because the Warren Bridge had already come into operation. And while it would not become free until after the Supreme Court's decision, the people had already seen the writing on the wall. Now, why do I talk about the Charles River Bridge case? Well, in part, it was an issue of how should one respond to to progress? How should one respond to changes in technology? In favor of the bridge were not an insignificant group of legal scholars and legal stars. Justice Story, in the dissent of that case, argued that this is a fundamental case about the American economy and the American way of life, because investors, right, people who are, these are not the monopolists of the kings of England, right, where the Queen decides to give a monopoly privilege and playing cards to a court favorite. These are investors. These are people who legitimately engaged in enterprise to the benefit of the public. And Story argued that unless we secure those investments for as long as that grant, that promise lasts, who will invest? Right, and ultimately, this country will be left in the Stone Ages, and progress will never occur in the United States. Now, of course, the problem for Story was, well, you could certainly interpret the bridge's original charter to imply a monopoly and an exclusive right against competition, especially by a neighboring bridge. It wasn't in the grant itself, right? For many respects, because they didn't think of it at the time. And Justice Taney, on the other hand, who, as many of you should be familiar, is no great fear or disbeliever in property rights, though not necessarily in the right context, argued that this was actually an inappropriate approach. He thought that the courts, in response to these questions, when we're talking about interpreting exclusive rights, should construe those exclusive rights narrowly because there are a couple of problems. One, it arguably usurps the power of the legislature to deal with this question specifically. And two, because there are fundamental problems with doing it. And the fundamental problem that Taney saw was the idea that this would mean that existing businesses and existing technologies would have a veto power over all other upcoming technologies and innovations. So in this case, the old bridge owner was trying to prevent a new bridge from being built. In the next case, the turnpike owners, right, the roads at the time, which were privately funded, would prevent the canals from coming in because the canals would destroy their business. The canals, in turn, would argue that their exclusive rights in the canals would prevent the railroads from coming in. And Taney ultimately was right in his prediction. After this case, and as technologies advance and new businesses enter the fray, those claims. Now, what did